Like, y'all don't even care. Y'all don't even care what's going on. You don't care?
We're done, sir. Step out of the booth.
Man, fuck you. Suck my dick. That's what you do. Faggot ass motherfucker.
64769, Kathleen Biebersheimer. Good morning.
Good morning. I apologize for my dress. I would hope that you don't hold me in contempt of court. I had to flee the place that I was staying because there was another false accusation against me for quote unquote throwing rocks at another that I was visiting a friend at. I'm asking for another continuance, and I'm changing my plea with prejudice instead of without prejudice because it's going against the lawsuit that I'm putting against the police department.
Okay, so that, I understood the first portion of that. There's been no plea here, and pleas aren't issued with prejudice or without prejudice. That's a dismissal and an order of the court.
Dismissal, I apologize.
Any motion for dismissal is denied. Ms. Biebersheimer, I do recall vividly the last time that we were here.
It was a false accusation for throwing rocks at the victims. The victim themselves, it's a false accusation. She had taken something out of my yard, and I wanted to press charges on her for doing so. And there was witness statement to it. That's where the witness tampering comes in. The police did not put any of those witness statements into it. There wasn't any witness to any of the assault because there was none. They put me in for an assault charge and then said they were going to investigate the theft and did none whatsoever. And they've also written me 7 other tickets outside of this again.
So I've found no new charges, but we were here on July 17th, and it is, there have been your last, there was a competency eval done in September of 2025, where you were determined to have been incompetent. Since that time, you've had a host of cases dismissed because the judge has adopted that finding carte blanche, and I
believe it's
dismissed.
I'm sorry.
A number of cases. These cases do involve allegations of assault and harassment,
which are false.
and and I understand that you do have the presumption of innocence. However, I am concerned today about your competency to proceed in these matters. And so I'm going to read you a competency advisement, and then I'm going to order that you comply with a new competency evaluation. Once I've read this to you, then I'm going to appoint the public defender to facilitate, and I'm going to appoint the Bridges liaison to facilitate you in getting a new evaluation with a new evaluator done. So as you know, once competency has been raised, you're going to be evaluated by a physician or psychologist. The court has raised competency. You are unrepresented, but the information provided by the evaluator will be provided to the court. You do have the right to remain silent during the evaluation. However, such silence will be used by your evaluators to determine your competency. Any statements you choose to provide to the evaluators may be used in the by the prosecution as either impeachment or rebuttal evidence if you ever testify at a subsequent criminal trial. Any statements you choose to provide in cooperation with the evaluation may be used at any sentencing hearing if these matters proceed and there's ever a conviction. You have the right to request an evidentiary hearing to contest any determination of competency, either that you are competent or that you are incompetent.
I did that the last.
You have the right to be reexamined by an expert of your choice on the issue of competency. A copy of any report generated by that expert would be provided to the prosecution. At a hearing, if you contest the competency determination, you do have the right to be present in person to examine any reports of the evaluation motion or other matters to be considered by witnesses called by the court, to introduce evidence, to summons witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make an opening statement and closing argument. If you are found incompetent to proceed, the criminal proceedings would be suspended, and you may be committed to the Department of Human Services for a period not to exceed the 50% of the maximum sentence of the highest charge. The 26M, yes. So both of these cases do contain an M1 allegation. So I am appointing the public defender and the Bridges liaison to assist you just with getting that evaluation completed, okay? It doesn't mean that you can't proceed in any suits that you, I do see that your suit against Palmer Lake was dismissed without prejudice on May 20th, 2026.
It's because I didn't serve the town.
Right. So, and that's why that was dismissed without prejudice. So this doesn't stop you from doing what you feel you need to do in those terms. It just means insofar as these criminal allegations against you will be suspended pending receipt of a new competency evaluation, okay?
Why has no one looked into this first ticket that started all of this harassment?
Well, I think once we get that new evaluation taken care of, then things can start getting looked into, okay? You still
this
and
into the
always
last
do
one.
have the presumption of innocence, and this doesn't go away. Whether you're found competent or incompetent, you always have the presumption of innocence.
I tied this into the last competency test.
Right, I understand that, but the judge, the 2024 case where that evaluation was completed in September of 25, that case was dismissed based on that finding. And then you had a host of other charges in Division J, 25M 6451, 25M 8202, 25M 8203, 25M 8204, 26M 853, 25M 6450. All of those just adopted that competency evaluation. And I'm concerned that just adopting a September evaluation and letting go of this is leaving you in the wind. And so if there's a concern that you're getting these additional charges and they're unfair and you're being set up, I think that proceeding with a competency evaluation in these cases, your arguments and your concerns are best served.
They didn't even tell me why they deemed me irredeemable.
Okay.
They just said I was deemed irredeemable. And I think it's because it's to cover up the fact that Judge Burney is allowing high school and Colorado college students to preside over law unbeknownst to defendants.
Okay. Well, so I was a little confused by the finding in that evaluation as well, which is why we're going to have this new evaluation. Okay.
All right.
All right. And so Mr. Alexander or Ms. Colvin will represent you to help you with if there's an evaluation and you're deemed to be competent and you want to get rid of them at that point, that's fine. But until we get this evaluation done, I'm going to have the public defenders appointed to help you out.
I'm filing against the public defender's office against Brianna Lindbergh as well, though.
Okay, well, if when that is filed, you let your current public defender know, and we can look into alternate defense counsel. But at this time, I'm not seeing any.
She wouldn't get me my body cam footage under the Freedom Act, and she wouldn't get me my core report either.
Okay, all right. Well, let's take baby steps here. Let's get this evaluation done, okay? Let's get this evaluation done. I'm going to set you out a bit.
And what happens now? I mean, I'm in fear of even going back to my own community.
I'm going to set you up for.
And there's an issue with
September 15th.
the Frey
at
effect as well.
1:30. September 15th at 1:30. And then I'm not seeing any new charges in here, which is good.
It might be in another court of law because they've written me.
Well, I only have, there's only two in town. There's municipal court, and you're right, I don't have access to those, so that they might be in muni court, but it's either this system or the Muni Court system.
So where do I go to find those to see if they've been dropped or
The
not?
municipal courthouse is on Kiowa. Let me get their address for you.
And what makes the difference between it would be written here and the municipal?
The level of charge and who's charging
It
and
was a federal crime.
if it's a
stealing
federal, it would
rocks
be written, yeah, but I think
from the
right now,
railroad.
what you're experiencing, you're probably 224 East Kiowa. That's the address for municipal court, 224 East Kiowa. And you can go down there and ask if there's any cases filed against you. Okay?
They put me in for federal charges for taking rocks from the railroad. They charged me a $4,500 fine.
Okay, well, the next time when you get your, if you must have paperwork for that, you can give that to your public defender, let them look that over, okay? All right?
So what happens if I'm written more erroneous charges again once I go back up to my town?
We're gonna figure that out. Like I said, I can't, if you go to Muni Court and you find that there are a bunch of charges against you, you should have been given summons for all of those. If you do have a copies of all those summons, you can always have your attorney look over, because those two would have to be suspended pending any competency. So whatever tickets you've been issued, if you just show Ms. Colvin those tickets, okay?
Am I able to take out a restraining order against the Palm Beach Lake Police Department?
I can't give you legal advice. I would venture to guess there's some probably prohibition against getting a restraining order against a police department, given the nature of their business. But
I mean, what do I do then?
so, well,
I
yeah.
don't have a telephone number right now. Well, that's my card.
If you, okay, do you have a contact information? Because they're going to have to get, you're going to have to contact them to get this scheduled. And so
I'm going to have to double check with the person that I give out the contact information, if that's all right.
well, at this point, I'm going to have to make it a condition of your summons
Okay.
that you
What kind of
contact.
boyfriend's telephone number? I'll give you my boyfriend's telephone number.
Okay. So it is a condition of your summons that you maintain contact with Ms. Colvin and comply with the competency
Sounds good, doesn't it?
proceedings. And I know you've complied with them in the past as well, so I don't believe that you're not going to be compliant. Okay? All right. All right, thank you.
I'm having this person who leaves. I'll be right back.
Okay, thank you.
This is matter of State versus Phillip under warrant 2026-231-1712. Counsel, your appearances, please.
Your Honor, Deputy Attorney General Angela Cefelli on behalf of the state.
Your Honor, Raymond Burke for the defendant, Lionel Billop.
All right, the state has filed a motion for pretrial detention. Are the parties prepared to proceed?
State is ready to proceed, Your Honor.
Defense is ready to proceed, Judge.
All right, this, first, Mr. Burke, your client has had his first appearance. Do you waive any further review of his rights or charges?
Yes, Your Honor.
All right, the state's filed a motion for pretrial detention. In that motion, they cite as grounds for detention that the defendant is charged with near qualified offenses, grave qualified offenses, as well as arguing that the defendant is a risk of not appearing in court, poses a danger to another person or the community, or is a risk of obstructing the administration of justice. Under the grounds cited in the motion, detention would be authorized under 2A162-19, A7, A1, and A5. Does the state continue under those same grounds, or do they seek detention on any additional grounds?
No, Your Honor.
Mr. Burke, what is the defense's position regarding probable cause?
Judge, we're going to stipulate the probable cause. The bar is quite low, and I've received all of the documents from DAG Cefelli, and I have reviewed same, so we're stipulating probable cause.
I'll hear from the state.
Thank you, Your Honor. The state previously provided exhibits to the court in defense marked S1 through S3, S1 being complaint warrant 2026 S231-1712, S2 being the PSA, and S3 being the Pennsville investigation report. And the state would like to move those exhibits into evidence for purposes of this hearing.
Mr. Burke, any objection to S1 through 3 being admitted?
No, Your Honor, we reviewed same and have reviewed them. Thank you.
S1 through 3 are now in evidence.
Thank you, Your Honor. So the nature and circumstances of the offenses charged here, the defendant was arrested and charged for the possession with the intent to distribute cocaine, possession of a firearm while committing CDS offenses, possession of CDS, receiving stolen property, possession of heroin, possession of cocaine, and first degree offense of the unlawful possession of a weapon with a prior near conviction. Additionally, this defendant is a certain person not to possess firearms. The facts of this case stem from a narcotics investigation occurring in Salem involving two separate residences, those being 18 Davis Avenue and the second being 217 Church Street. Law enforcement learned throughout the course of their investigation that narcotics were being distributed by Kevin Barr, who goes by the street name Boogie Down, Tramaj Billup, and this defendant, Lamel Billup. Law enforcement became aware that 18 Davis Avenue was the defendant's residence and place where he would distribute and store narcotics. On July 23rd, a search warrant was executed at the residence of 18 Davis Avenue, and the defendant was at the residence and detained. While conducting the search, officers seized a black Sig Sauer 329mm handgun, serial number 58J325574, with a red dot optic on top. The firearm contained a loaded extended magazine with one spent casing and hollow point ammunition with one round loaded in the chamber. It was later discovered that this gun was stolen out of Poughkeepsie, Pennsylvania. In the same drawer where the firearm was seized, approximately 0.6 ounces of suspected crack cocaine in a clear plastic baggie, 20 wax folds of heroin in a separate clear plastic baggie, and multiple empty wax folds in another clear plastic baggie were also seized. In the same dresser, officers located a small blender with white powdery residue. In a dresser located next to the bed, officers found more empty wax folds, and in the dresser drawer directly next to the one containing the handgun and suspected narcotics, officers located this defendant's wallet containing his New Jersey ID and medical insurance cards with his name on it, as well as multiple prescription bottles, all prescribed to this defendant. The defendant was read his rights. Officers then advised the defendant what was found in the house, in which the defendant responded by stating it was his, and then described the gun that was seized as a 9mm black handgun with a scope. The defendant also indicated there was a little bit of dope in the top dresser. The officer then asked the defendant if there was anything else in the room, and defendant stated some cocaine. Defendant also indicated that no one stays in that room with him. This defendant, the state believes that the weight of the evidence here is strong. Throughout the course of this narcotics investigation, police learned that this defendant was distributing narcotics from his home. A court authorized search warrant was executed in which a firearm was seized. Right next to the firearm, over half an ounce of cocaine was seized, as well as less than half of an ounce of heroin. Various packaging materials and paraphernalia were also seized. The defendant admitted to officers to possessing the firearm and the CDS, and additionally, the firearm in the defendant's possession is a stolen firearm out of Pennsylvania, and this defendant is a certain person not to possess weapons. This defendant has 4 prior indictable convictions, one of them being a prior violent conviction of first-degree aggravated manslaughter. The other convictions include a third-degree hindering oneself, a second-degree distribution of CDS within 500 feet of certain public property, and third-degree terroristic threats. It does appear that this defendant has an active TRO from 2022 in which he was also prohibited from possessing weapons. While this defendant does not have any prior failures to appear, does have a prior hindering conviction from 2024. Additionally, this defendant failed to follow the conditions set forth in his active TRO. Specifically, he was prohibited from possessing weapons and clearly was in possession of a firearm in this case. Here, the PSA scored the defendant 2 on a scale for failure to appear and 3 on the scale for new criminal activity, and there is a no release recommendation. The state requests the court follow the PSA recommendation and detain this defendant pending trial for all the reasons previously stated, and most importantly for the fact that this defendant is a danger to the community as he possessed a stolen firearm while committing CDS offenses, particularly distributing CDS from his home. and this defendant is a certain person not to possess firearms and is prohibited from possessing firearms. For all those reasons, it is the state's position that no amount of monetary bail, non-monetary conditions, or any combination would reasonably assure the defendant's appearance in court, protection, or safety of any other person or the community. So for all those reasons, the state submits that the defendant should be detained pending trial.
All right, Mr. Burke.
Thank you, Your Honor. As the state pointed out, his PSA score is 2-3. He has no pending charges, no disorderly persons convictions. He only has four prior indictables. The last one was in sentence in 2022. He has no failures to appear on his record whatsoever. Judge, he is a Salem lifetime resident, Salem County, New Jersey resident. He has some community college. He has his
He was drug dealer of the year in 2024.
High school diploma.
Pillar of the community.
He suffers from PTSD resulting from a shooting incident back in 2021 where he was shot multiple times. He has a problem with substance abuse. He takes multiple medications for that. He's back in 2024. He had open heart surgery and suffers from congestive heart failure. So his medical condition is quite severe. He won't be able to get treatment for all of that in the jail, obviously. He has he doesn't have any failures to appear. He's not a risk of flight. Obstruction, Judge, I don't see any possibly maybe one third-degree hindering charge. He, in fact, if you believe the state's evidence, he cooperated with police during the investigation of this incident. So that shows that he wasn't obstructing anything at that point. And Judge, given all of that, he's on the waiting list for Penn Village and Gardens. I believe it's a substance abuse situation, a place so that he can be released there to get the treatment he needs and the treatment he needs for all his other matters. And with that, Judge, we feel that the state's failed to meet its burden, that there are no conditions that can be imposed upon him to ensure his appearance in court, that he won't obstruct evidence and is a danger to the community. So, Judge, for all of that, the defendant submits on the issue of detention. Thank you.
It's the state's burden. I'll give the state the final word in response.
Thank you, Your Honor. I know defense just mentioned that this defendant has a room waiting somewhere for a substance place. There's no evidence of that. State never received any evidence of that, and the state would just rely on all the previous stated reasons for detention. Thank you.
The case against the defendant seems particularly strong. The charges are quite substantial. And given the defendant has a prior aggravated manslaughter conviction and he's found to be in possession of a firearm and a distribution quantity in the second degree, the defendant has served a substantial period of incarceration on the aggravated manslaughter charge. He received a sentence of 16 years in state prison. It would be a near qualified offense, so he would have been serving 85% of that 16 years. So it's no surprise that he has little or no failures to appear because he was in state prison the whole time. And the 2022 matter for hindering, he also received a 3-year state prison sentence. So those are significantly notable. The question before the court is whether or not there are any conditions or combination of the conditions that will assure his appearance, protect the safety of the community, or risk of obstruction. First, as I noted, as both counsel noted, there is no failure to appear history. I know what I perceive the reason why, given the nature of his charges and indictable convictions. He had substantial jail and prison sentences, so he's likely pretrial detained on some of it. It's interesting that he was convicted of a second degree possession with intent to distribute CDS in proximity to public property, but it's noted that there's no sentence, so that more research might be needed in that regard. When I say no sentence, in terms of no period of state prison on a second degree. But he has no failures to appear, and you know, you can glean that from the record. It's the likelihood is that he was probably in jail pending these cases and these charges. I find that he is not a failure to appear risk. Is he a risk of obstruction? We certainly have an indictable conviction for a conviction related to obstruction, that being hindering oneself or evidence issues in the third degree. Notably, he got a state prison sentence for that particular offense. So there is that risk, and that's really sort of the only thing I can necessarily hang my hat on. The question really comes down to whether or not the defendant is a danger to a particular person or the community. I can't, and neither party identified that the defendant would be a risk to a particular person. So the general, it would be generally whether he is a risk to the community as a whole. I mean, generally somebody who has an aggravated manslaughter conviction, a hindering apprehension conviction, terroristic threats, drug dealing, is a general danger to the community when the new charges are his possession of a handgun, his possession of distribution quantities of drugs. I think it's pretty easy to say that anybody with a aggravated manslaughter conviction can't be in possession of a firearm. Even if he was subject to a shooting at some time in the last few years, that does not justify his unauthorized illegal possession of that firearm. To say that, you know, he's got medical conditions and these medical conditions make it less likely for him to be problematic if he were released. Well, those medical conditions did not prevent him from possessing a firearm. Those medical conditions did not prevent him from being involved in the distribution activity that was investigated. And apparently he has a substance abuse issue. I guess that he's either self-medicating with the heroin or cocaine or crack. We don't know. I'm going to grant the motion for detention. This defendant is a danger to the community, given the nature of his indictable convictions, of which he only has indictable convictions, and the nature of the charges here makes it clear to this court that he is a danger and that there are no conditions or a combination of conditions that this court would set to ensure the safety of the community. So he'll be held pending a resolution of his charges. He is to be afforded all opportunity while detained to meet with counsel. He may appeal this court's determination on an expedited basis. The next court hearing for this will be a pre-indictment conference before Judge Chetney in Salem on September the 10th at 9 a.m.
They're not even handling my medical situation now. They're not even handling. I got bone and spine problems. I had a medical procedure I had to get done on Thursday. It didn't get handled. Last Thursday, it didn't get handled. I call and bang on the door for my open heart surgery, my chest hurting. Nobody comes. Like,
right, so you're detained. I will alert the jail that there's concern for your medical conditions. But other than that,
my medical conditions is not being met. This is what I'm telling you.
Okay, and I hear you.
No, I hear you. You don't know what's going on.
That concludes the matter, sir. You can step out of the booth.
Hey, leave me in a room to die in it. Like, y'all don't even care. Y'all don't even care what's going on. You don't care.
We're done, sir. Step out of the booth.
Man, fuck you. Suck my dick. That's what you do. Faggot ass motherfucker.